Supreme Court of Order is now in session. Please be seated.
We turn now to the third case on the docket, American Southern Home Insurance Company versus Lentini.
May it please the court, RAOUL CANTERO for American Southern Home Insurance Company, and I'm reserving 5 minutes for rebuttal. The issue in this case is whether insurance policies on collector vehicles can limit coverage to accidents occurring within that vehicle. And we submit that they can. And we ask the court to approve the Martin's decision, the second DCA's decision in Martin, and to quash the decision in this case. Let me start by explaining the actual policy provisions in this case. This was a 1992 Corvette on which there was $300,000 in coverage. On page 8 of our appendix, there is a policy overview that explains to the insured exactly what is covered and how the policy is limited. It is a specialty policy specifically designed for collector vehicles. On this car, mileage was limited to 1,000 miles per year. It could not be the primary vehicle used by the insured, and the policy specifically required, and it's on page 56 of the appendix, that the insured have a primary vehicle for everyday use. The car could not even be used as a substitute for that primary vehicle. It also had to be stored in a fully enclosed and lockable permanent structure and could not be the principal means of transportation.
Can I ask you a question? What does uninsured motorist coverage mean as used in the statute?
Uninsured motorist coverage means that when someone is injured by a tortfeasor who does not have insurance or whose insurance is not sufficient to cover the damages, meaning underinsured, that it would cover the damages for that.
And that's true if the person is injured in a different car or is injured by a pedestrian who's uninsured, correct?
In the normal case, yes.
So that's what it means, right?
Yes.
Okay. If that's what it means and the statute requires that, and that's the scope of what uninsured motorist coverage is, then doesn't every policy that is an automobile insurance policy, in other words, any policy, have to include those or incorporate those things?
Well,
unless specifically waived under subsection 9.
That leads directly to the Mullis case. The statute itself does not require that uninsured motorist coverage travel with the insured.
So I guess that's why I asked you that question. So I'm focused on the statute. I want to know so the statute uses a term. It uses uninsured motorist coverage.
The statute says that every policy providing coverage in Florida has to include uninsured motorist coverage.
Right.
It does not say that coverage has to include other vehicles. It doesn't mention that at all.
Okay. So what is your best understanding of what that term means? Because to me to me at least, that's a dispositive question of
yes.
It has to, in a policy, any automobile policy has to cover what the statute requires.
The statute just is silent on whether it requires when you're a passenger in the vehicle, when you're a driver in the vehicle, or when you're in another vehicle.
So let me ask you this. Does subsection 9 tell us what it means? In other words, subsection 9 says you can exclude these things under certain conditions. And I know your point is you could do it under other conditions too, but if it means that you can exclude under these things, doesn't it have to include those things unless excluded?
Well, that's an interesting point here, Your Honor, because the statute, section 9, the only possible provision that would apply is 9D.
I think everyone agrees with that.
And 9D says, I'm not going to read the whole thing, but it says, for which uninsured motorist coverage was not purchased. And so it depends on your reading of not purchased. In the Douglas case, the insured did not purchase any at all.
Right.
Our insurance policy does not contemplate that the insured would not purchase any at all.
Well,
it contemplates that they would have a separate policy with uninsured motorist coverage.
If you can answer my question, though, and I want you to get to that. Please get to the point you were making. But do you agree with me at least that uninsured motorist coverage as used in the statute has to include those things which subsection 9 allows to be excluded?
Generally, yes.
Okay. So if we were to find, if I just take that one step further, if we were to find that one of those things in subsection 9 was subject to here and wasn't, and the form that's supposed to be used by subsection 9 wasn't in fact used, then that would include uninsured motorist coverage would have covered that, and this policy would be contrary to that.
Not necessarily.
Okay, tell me
Let
where I'm wrong.
Explain why.
Tell me where I'm wrong in there.
There are various answers to that, and I know that's really the crux of the issue here, so it's good that we're getting into it immediately. Number one, I think it can't be lost on the court that in Martin, the second DCA had this issue, decided that you didn't need to provide the comprehensive coverage, and that case has stood for 21 years until the Lentini case from the fifth DCA. And that under this court's decisions, the inaction by the legislature for that period in an interpretation of the statute, which they could have easily fixed, is a determination by the legislature that they're okay with that interpretation and that they don't need to change it. And so this court has said in Malu and in other cases that we've cited that the legislature's inactivity after a case interpreting a statute is evidence that that's a correct statutory interpretation. There's no reason for the court.
It is true, our cases have talked about that. I have a little trouble understanding the concept of action by inaction in the context of the legislature, where it can be the case that one person in the legislature will have the power to stop action, and there might, that's just the way the process works. So to draw a conclusion from that about what the legislature originally intended, which has to be the argument, it seems to me to be problematic. How do you respond to that?
Your Honor, I think it's unfortunate for me that we have a former state representative on the court that knows the workings, but the cases from this court don't make that distinction. There are more than one case that says that legislative inaction is evidence of acquiescence with the decision. So the majority of the court in other cases has not said that, well, somebody has the ability to stop it in its tracks and therefore it's not really evidence. They've said that it is evidence.
Let me shift to another question, and this may have no relevance to any of the issues here. Am I correct in understanding that the policy at issue here was a stacked policy?
Yes, it did say stacked, but the stacked in the context of this policy was stacked in the event that the insured obtained another collector vehicle.
Where is that written?
It isn't written anywhere.
So that's just your position. What would stacked ordinarily mean?
I'm sorry?
What would stacked
Well,
ordinarily
ordinarily it
mean?
means it's stacked with other insurance.
So there's a special
other
kind
cars
of
that are
stack.
insured.
There's a special kind of stacking here.
Yes.
If we had the regular kind of stacking, that would not be consistent with your position, right?
Yes. Yes. And it's clear this is a special standalone policy. It's not one of those policies that you have different options of what to do. If you want comprehensive coverage, you just get a full policy and you're charged a full premium, including premium for uninsured motorist benefits. The consequence of ruling that this is void is that insureds somebody with a collector vehicle won't be able to get cheap insurance on a collector vehicle that they're only going to drive for at most 1,000 miles a year.
But couldn't they do that if the insurance company just had the consent form signed as to that issue?
Well, this policy has more limitations than just that issue. It has liability limitations as well.
Right, but isn't that the issue here is that you have to have consent? If you don't want uninsured motor vehicle coverage, you have to specifically consent in writing that you're declining that coverage.
Yes, again, if that provision applies, which we don't think it does, depending on how you read for which uninsured motorist coverage was not purchased.
But in this declaration, it specifically includes uninsured motorist coverage, does it not?
Yes, it does have uninsured motorist coverage for those driving the vehicle or passengers in the vehicle, no question, yes. I think Justice Muñiz had a question.
So we're trying to figure out what uninsured motorist coverage means under the statute. And it sounds like from some of the questions and answers here that there's a suggestion that we have to sort of infer what it means by looking at this subsection 9. And that in the absence of that, there might be more leeway to to try to figure out other ways of figuring out what the term means. Can you kind of walk us through the evolution of the statute? Because I'm trying to figure out if we don't sort of define uninsured motorist coverage in relation to what's not, to Section 9, I'm trying to understand how else we would figure that out, what the term means.
Your Honor, I think we start with this court's decision in Mullis. And in Mullis, that's when the statute itself doesn't say that the coverage has to travel with Class 1 insured. And the issue is that, in that case, was whether it did or not, whether you can limit it to the car in a family policy. And again, we distinguish Mullis because Mullis itself talks about family protection. That's the normal policy you get with comprehensive coverage. But in Mullis, for the first time, the court said that an uninsured motorist benefit has to cover not just when you're a passenger in the car, but anywhere that you are, because it's designed to protect, just as if you're liable under the insurance policy, even if you're driving another car, then you have to be protected from damages, even if you're not driving another car. So that was not in the statute, and the court interpreted the statute that way. After Mullis is when subsection 9 was enacted, and under the cases that have interpreted, including this court's case in Harrington, 9 is essentially a stacking provision, which has allowed stacking of uninsured motorist coverage. And what stacking means is you can say that the limits on my uninsured motorist coverage are not just, for example, the $300,000, but also whatever the limits are on other cars that I own for which I have uninsured motorist coverage. So if I had $3,100 on another car in my house, then the limits are $600,000. Or I can buy unstacked for cheaper, in which the limits remain $300,000. So the cases have said that this 9 provision is essentially a stacking provision that allowed for the choices of stacking or not.
But does is the exclusion that we're talking about here, is that essentially an anti-stacking provision? I mean, is that functionally what it's doing?
Well, the court, I don't think, has interpreted as an anti-stacking provision. I think in the Douglas case, there was a big discussion between the majority and the 3 dissenters about what kind of a provision it was, because the dissenter said, look, this is in a stacking provision, and now you're reading as if in the middle of A through E that are about stacking, now you have this D that you say is more than just about stacking. But even if it's about more than stacking and it just says you have to get the consent, the way we read it is if you have to get that consent, or you can get that consent where they have not purchased there's a car where they haven't purchased any uninsured motorist coverage, as happened in the Douglas case. And here, we require the insured to have another car which is their primary vehicle, which would then have all the liability and all the coverage. So that's why our argument is this does not upset anything that Mullis intended to do of protecting Class 1 insureds, which are the insured and the family of the insured, that protects Class 1 insureds no matter where they are, because they will still have a family vehicle with family protection on that car. This is supposed to be a very narrow, very limited policy with the commensurate, very cheap premiums for that policy, which were $58 for the year in this case.
I mean, I don't think there's any question about what the policy was trying to do. I mean, I think the challenge is that the statute says, any insurance policy, and the challenge that I think we're having is, is this subsection 9 a de facto sort of comprehensive regulation of what uninsured motorist coverage has to mean in the absence of someone going through, that this is a limited sort of menu of exclusions that are available, and that if the customer and the insurance company want to bargain for that, it has to be pursuant to the specific form and with the consent and everything. And I think that's the struggle. The struggle, it's not what the policy said or what the bargain was or anything. I think it's just a question of, does the law trump that? And why, your argument, I guess, is that 9 isn't what I've just described, and I just want to see what the best case for that would be.
So I can't argue that it's a stacking provision, because it just doesn't seem to be a stacking provision by the plain language of that, but we're saying it doesn't apply in our case, and we're also saying, despite the Chief Justice's resistance, that Martin's been out there for 21 years, and for 21 years it was the law in Florida, because there was no contrary decision, and therefore all the courts in Florida had to apply it, and the legislature for 21 years never had a problem with it and never fixed that, and so the legislature seems comfortable with having collector vehicle policies, just like business policies that limit coverage as well. And we cited Sterling and the Weiss cases, both uninsured motorist provisions, and both were business policies where he said, no, you can limit a business policy. They seem comfortable with that concept and haven't deemed it necessary to change the law.
And at one point in your brief, it seems like there's a lot of policy arguments that you're making in terms of just the business, sort of the common sense aspect of this. But you do say a couple of times in your briefing that your position best accords with the text. And it doesn't seem to me that, Martin doesn't seem like a particularly text-based decision. Can you give us your best argument for why, if we're focused on the text, you should win?
Well, because number one, the requirement that we fulfill the requirement of uninsured motorists. There's nothing in the statute that requires it to follow Class 1 insured. That was a decision by the court in Mullis, which we think is fine for family vehicles, but doesn't need to be applied in this context. And
is there anything in the text that supports that distinction?
It doesn't support, the text doesn't support a Class 1.
Well, no, but we've got that law. And that's our law, right?
Yes.
Mullis is our law.
Correct.
So is there anything in the text that supports the distinction that you want to impose on what we decided in Mullis? What do you look to in the text that would support this distinction that you're making?
That the text doesn't require uninsured motorist coverage to follow the Class 1 insured. It doesn't say anything about that. It only says that.
That's as true for every policy as it would be true for this. So I don't understand how you're saying, well, that only applies there, it doesn't apply here. What in the text supports it applying there but not applying here?
No, all I'm saying is the statute requires that all cars in Florida, garaged in Florida, with policies in Florida, have uninsured motorist coverage, and we do have that.
But you're saying that it doesn't, because it's a specialty car, it is not appropriate, and the policy itself says there is no coverage other than for the Corvette, correct?
Yes.
It doesn't apply to any other vehicles you may have, because this is a short premium, a small premium for a collector car. Therefore, it doesn't go with that other car if there's if there's an accident.
Yes. And I'm saying there's nothing in the statute that prohibits it or authorizes it, just silent as to that. I'll save the rest.
You think Mullis was wrong?
No, but Mullis should be confined to family vehicle protection, which is the overwhelming number of policies in Florida.
What in the text supports so confining it? That was my question.
Because the problem is there's nothing in the text that supports the Mullis decision in the first place. Mullis was.
So maybe you think Mullis is wrong.
I'm saying that Mullis is fine for family vehicle protection, but doesn't need to be expanded.
Not your case.
But if the statute doesn't if the statute doesn't draw those distinctions, why isn't Mullis wrong? Mullis was not based on, as I read Mullis, I don't know how Mullis is connected to the text.
Well, you may find Mullis wrong, but you don't have to in order to rule in my favor. That's what I'm saying. And I'll save whatever time remains for both.
Very well.
But
I will afford you 2 minutes.
Thank you, Your Honor. Appreciate it.
Thank you.
May it please the Court, John Bogdanoff for the Lentini estate. This Court's asked to resolve the conflict and determine whether Martin correctly adopted an insurer-created and imposed version of limited uninsured motorist coverage for a Class 1 insured who owns a specialty motor vehicle. They did it on the basis that there were policy considerations primarily that warranted that recognizing that type of exception. And I believe, as Justice Muniz has indicated, the wording of the statute, the uninsured motorist statute, is very clear that it does encompass any motor vehicle. A specialty vehicle is any motor vehicle. There is no exception in the statute.
Yeah, but that doesn't, that's the easy part of the question. The hard part, policy clearly covers it. I can only speak for myself. The hard part for me is, what is uninsured motorist coverage? And that's the questions that I hear the struggle about. To me, at least it has to cover, I don't know that I know the answer, but I know it seems to me to at least have to cover what's the negative implication of subsection 9. In other words, if subsection 9 says you can consent around these things, then the legislature seems to be saying that these things are in uninsured motorist coverage. Would you agree with that?
Yes, and I believe that derives from the fact that in 1971, this Court issued the Mullis decision, where the Court indicated that uninsured motorist coverage follows the insured. It does not follow the specific.
Where is that? I'm sorry.
No, I was just going to ask, I apologize. So that's the legislature's attempt to try to codify what's in Mullis to say, this is what's included, and you can consent around these things by filling out a form, giving information to the insured.
Right. Mullis makes a strict prohibition on whittling away uninsured motorists by way of exclusions. I think subsection 9 says we will recognize these for exclusions, assuming there's a knowing and affirmative rejection, which the legislature then in 1982 required be in writing.
So which one would apply here? Because what, as I understand it, everyone seems to be arguing around subsection 9D, and your opposing counsel is saying that 9D does not apply because there wasn't a purchase of a policy here as interpreted by Douglas and some of the other cases. If you can respond to that for me.
The 5th DCA, in their opinion, indicated subsection D, but then noted that there was no written rejection. So I think that's what the 5th DCA has determined.
Do you think that's right?
I don't know that we need to decide that, because in the absence of a written rejection, I don't know that that is really controlling in this case.
But if that defines the scope of Mullis, if in other words that's the legislature's attempt to define the scope, and this is outside the scope of what needed to be consented to, then isn't this not uninsured motorist coverage? Isn't this something else?
No, this is well within the scope of Mullis and well within the scope of the statute. I think if you read them both together, there are only a few exclusions that can be agreed upon, and that did not occur in this case because there was no compliance. Mullis is very clear that there are no exclusions to be used to whittle away uninsured motorist coverage, because the purpose of uninsured motorist coverage is to compensate the insured in the event the insured suffers damage or if there's a wrongful death situation caused by an uninsured motorist. It follows the insured,
But where,
not
that
the
goes to my
vehicle.
question. Where in the text does it say that uninsured motorist coverage follows the insured, other than in the Mullis decision?
It doesn't. It says it in the Mullis decision. But over 48 years, not only has the legislature amended the statute many, many times, but they've even strengthened the requirements of Mullis by saying in 1982 that any rejection has to be in writing. It can't be oral. So the legislature has indicated full agreement with the decision of Mullis that uninsured motorists is an extremely broad concept. It's to be liberally construed, and it's not to be whittled away by exclusions, which is exactly what happened in this case.
But they've not done the same for the conflict 2nd DCA decision?
Well, no, because Mullis, it's not only Mullis, it was a series of decisions out of this court. Mullis, Douglas, Young, there's others that we've cited in our brief that have established and continue to recognize that principle. And so over time, over this 48 years, it has been a steady and very firm statement of principle, and the legislature has not only appears to have agreed with it, they've made it even stronger in 1982 by making written rejections a part of it. So it appears very clear that there's no real dispute here as to the fact that these are the principles of uninsured motorist coverage, and they're the principles that guide policies written in the state of Florida.
Let me ask you this. Could the insurance company and the insured have agreed to the limited coverage as it purports to exist under this policy by signing a consent or waiver under 9D?
Well, I don't
That's
think...
an easy yes.
Right.
Yes
I
or
don't
no?
think so, because I
Okay.
think that would be whittling away the exclusion, creating an exclusion that isn't authorized. If it is authorized under 9D, and the 5th DCA did interpret and address 9D, then it may be that the insurance company could have done that by way of a appropriate written rejection, but that did not happen in this case. And so what we have is we have an insured.
But I'm hearing you say if they had done that, you would have said it would have been ineffective because 9D doesn't expressly address this.
Well, I think that's, yes, and that issue wasn't fully fleshed out.
Right.
So like I said, I don't know that we need to address that, because I think the issue here is, does Martin, in creating a judicial exception to Section 627-733, did they cross the line into legislating instead of just interpreting the statute? Because they didn't just interpret; they created an exception.
But I do think it's an important, because what you're asking us to essentially interpret the statute in a way that would make it a very strange statute in terms of what the legislature was trying to do, because it's clear that you can completely, with the proper informed consent, you can completely deny uninsured motorist coverage altogether, right? The insured can agree that they're waiving it.
With a written affirmative.
So I can waive it entirely, or I can opt for one of these exclusions that are specifically listed in 9D. But if I want to negotiate, if the insurance company and I want to get together and agree to something sort of in between that, and there's good premium, 100% information, understanding as to what I'm doing, you're saying that the legislature intended not to leave that as an option for the parties to this contract.
I think the legislature set out the parameters for uninsured motorists,
So
and they did that.
But does that make sense to you?
Yes, because I think they empowered the insured to make the decision in the context of the uninsured motorist statute. And so the insured has the ultimate decision-making, not the insurance company. In this case, the insurance company made the decision to impose the limited uninsured motorist coverage that it did. There's no written rejection, so...
But the way you're describing it is sort of a battle between the company and the insurer, but what it seems to me, though, that you're also suggesting that the legislature has given the parties to this agreement a very limited range of options, and the ones that you've put out for us, it just doesn't seem to make sense. Why would the legislature give you the ability to waive it altogether, but not have it a knowing bargain for something that was something, in between waiving it altogether and this menu in subsection 9?
Well, I think the legislature set out the format, and what they want to make sure is that insureds know what they're getting, or know what they're waiving. And so in order to do that, there's a statutory mechanism.
But here,
Mr.
there's no question.
Are you essentially saying that you may be right, that's bad policy? It would make a lot more sense if consumers had more options and insurance companies had more options, but there's no statutory basis for making that distinction.
I think that would be a legislative issue, which is why I think this whole issue is appropriate for the legislature, is because whether there is going to be a limitation for specialty vehicles is something that the legislature would be the most appropriate body to do after conducting a study, after getting information, after making a determination as to whether public policy warrants such an exception. That's not what occurred here. The way the statute's written now is there is no exception for these types of vehicles, and compliance with the statute is required. That didn't occur here. If there's going to be an exception, that exception should be addressed across the street by the legislature, which can easily address that and make a determination based on determination of public policy as to whether such an exception is warranted.
Isn't some reason for that because these forms of insurance cannot be done in a vacuum? They have to be approved by the Department of Insurance in a regulatory fashion in some way, right?
Right. The forms have to be approved. That are used have to be approved. So it's not just a case of, writing down something on a piece of paper.
And it impacts administratively how those premiums can be charged, what can be appropriately charged, and that's in a regulatory format as well?
Yes. So all of this is part and parcel of the statutory scheme, which is a detailed scheme and which everybody knows, and it's designed to protect the insured. For instance, in this case, it may be that the insured would have agreed to a lesser form of uninsured motorist coverage, but if that's not provided for by the statute, then we have to go by what the statute says. And in this case, the statute says all motor vehicles. This is a motor vehicle. There's no recognized exception for it. And the second DCA in Martin, in coming up with its policy rationales, across the line and got into an area where, as the fifth DCA said, it's appropriate for the legislature to make that determination, and that's not what occurred here.
Let me ask you more of a philosophical question. So the policy considerations in Martin are sensible, and there's no question that that was the law in Florida once the Martin court issued that opinion. That's the argument on the other side. So it's understandable that parties would conduct their affairs in accordance with the law, and insurance forms would be approved in accordance with the law. But we're addressing a statutory construction issue, and the statute says what it says. What is the right way to consider the fact that the law has been what it has been, and people have economic expectations that are that form around the law as pronounced in opinions, but it still is inconsistent with what the statute says. How do you?
Well, I think a district court of appeal decision is just that. It's a district court of appeal decision, and another district court can come along and disagree with that. That's what occurred here. The insurance company, had the option. In fact, they were probably were in the best position if they felt Martin needed to be implemented statutorily, to go to the legislature and say, look, here's an issue we have. We think you need to amend the Uninsured Motorist Act to provide for these specialty vehicles. They didn't, and here again, we can speculate. Maybe they were, felt, okay, we have a decision that's binding on all trial courts throughout the state of Florida, even though it's a district court appeal decision. We'll stay with that. We won't go over to the legislature and try to maybe do something, and maybe it's not going to work, or maybe they're going to require certain things that we're not going to be happy about. So we'll live with Martin, and it's binding on all the trial courts in the state, and we'll take our chances. They were in the best position if they felt. Certainly, if they would have lost in Martin, we can presume that they would have gone to the legislature and asked for some sort of legislative relief by way of amendment to the statute. But they prevailed in Martin, and for whatever reason did not go to the legislature. So here we are. I think today it's appropriate, as the fifth DCA said, for this issue to go to the legislature to make a determination as to whether these specialty vehicles should be accepted. There again, that's an issue of separation of powers. I don't know that Baron de Montesquieu ever thought that his name would be associated with uninsured motorist coverage, but here we are, separation of powers. It applies to a more mundane subject such as uninsured motorist coverage, just as it applies to more glamorous issues that are not before this court today. So we believe that's where the remedy lies.
Has there been any sort of administrative review or approval of this specific contract, this specific policy?
Not that I'm aware of. I don't believe the record indicates that.
And the motorcycle accident that led to the insured's death, did that involve the negligence of a third party?
Yes. Yes. So, are there any other questions? Thank you so much for your time.
Regarding the motorcycle, the evidence in the record, there were requests for admissions in the record. Some they were attached, I believe, to the motion for summary judgment. But the request for admissions, the response, which is at record 134, admits that the motorcycle he was occupying at the time of the fatal accident was a listed vehicle on a policy of insurance issued by another carrier. So it is the case that he did have insurance on that motorcycle. There's nothing in the record about any other owned cars except for the fact that our policy required that there be a primary vehicle.
Do you know if it was uninsured motorist coverage?
We don't. We don't.
That's pretty
The
important.
record is pretty sparse in this case.
That's pretty important, though.
Yeah.
And the fifth certainly seemed, and your co-counsel, your opposing counsel mentioned this, the fifth seemed to suggest that it wasn't purchased regarding.
Yeah, I didn't see anything in the record one way or the other. This court in Harrington and Flores has also said that a policy may contain other conditions or exclusions on coverage as long as they are consistent with the purposes of the statute. And I submit to you that this kind of coverage is consistent with the purposes of the statute and even with Mullis, because it requires that there be a primary vehicle with family protection, which includes all of the benefits. So there is no prejudice to the insured by this policy, and in fact, a lot of benefits to the insured by having a policy like this. There aren't many, there isn't much testimony in the record, but at R494, there's a deposition of in one of the insurance companies that was the servicer for this, and he testified at page 44 of the deposition that this coverage was about 20% of the usual premium for coverage. And so it isn't like the statute requires that in return for that consent that the premium be discounted by 15 and 20%. I think the statute says here it was discounted by 80%. So this is designed to be a totally different animal than in the usual family protection, and in return for that, the insured gets very cheap coverage. And I ask you to quash the decision of the 5th DCA. Thank you very much for your time.
Thank
All
you.
right, we thank you both for your arguments.